Okay, I've been helping this guy in terms of trying to understand some of the criminal procedure, and he's been trying to do the commercial acceptances for value. And it's interesting that the response he got back from a judge at a hearing is the judge said to him that what he's done so far is not right and it's being rejected. What the guy has done so far is he did a conditional acceptance for value. And I said, yeah, I think the judge is right. I think you aren't doing it right. And so we went over some things this weekend. Would you like to get a question or a comment in before we can?
This is Joe. I just want to go back to that little thing you said about rebuilding Babylon. I'm not sure I buy that, because we rebuilt Japan, and we're not Japan, and we rebuilt Germany, and we're not Germany. So I'm not sure that I can accept that we're rebuilding Babylon, now we're Babylon.
Is the creditor the head or the tail? Does the tail own anything that he possesses? If we rebuilt Japan, who loaned him the money to do it? Has the debt been paid back? If it hasn't been paid back, are they really the creditor of their own nation? If they don't own their nation, is it their nation?
I don't know that Japan owes us anything. I'm not sure. No.
Did they pay us back?
I don't know that they borrowed anything.
Has anyone paid us back? It's true, they're not supposed to, because there is no money.
Well, you say
but if they've dishonored us by not requesting that the debt be discharged by an exemption, then the debt is still on the books and being carried on the books, and we're still the creditor and they're the debtor.
So you're saying we're Japan too, and we're Germany, and...
You bet. Why do you think Standard Oil of New York controls Japan through Sony? Et cetera, et cetera.
I have just the one question here on this. Do these leaders of these nations know what's going on, or are they just in the dark as much as everybody else? And just the bankers knowing...
At what level? There's plenty of people at many levels that understand what's going on. My dear friend Dr. Jacqueline, who has understood the money system for a long time and was born in a third world South American nation and has traveled extensively and knows many, many world leaders and state treasurers on a first-name basis, has been trying to teach some of these people for a long time what's going on. The issue is, what do you do with a nation that's in debt to the IMF? How do you extract them from it? A, is it possible? B, is it desirable? C, what are the consequences if and when you try to extract yourself and can't? Remember, probably one of the biggest problems that Iraq had is it redenominated its oil contracts in terms of Eurodollars instead of Federal Reserves. That probably, more than any other reason, was the purpose for the coalition attack on Iraq. And it was most likely the reason that neither France nor Germany, who predominantly want Eurodollars to be preeminent over U.S. Federal Reserve notes, why they were against that action. And if you notice now, the international bickering is going not from, well, let's not get into that country by war, and the current issue is, well, you got to understand the UN has got to resolve that nation's issues now. And the United States and England are going, are you kidding? The U.S. is going to resolve that issue. And of course, Tony Blair is trying to keep a center line to keep his people at least somewhat in there. But the whole issue is probably Federal Reserve notes versus Eurodollars.
What is the what would happen if the Federal Reserve Bank? There's a provision in there somewhere in their books as far as it being dissolved.
Sure there is.
What would happen as far as in this country? And that
What do you want to take its place? You want gold to take its place, or you want another private currency like Eurodollars to take its place? But see, if we get back to gold again, then you're going to have a republic and a nation. Haven't you read Leviticus 26 and Deuteronomy 28? Because you're not going to get back into a condition of being sovereign in your nation as long as your nation's in violation of the Father's laws. Read Leviticus 26 and Deuteronomy 28. He makes it very plain that if you won't follow His laws, which means you're going to be a servant instead of a master, that He's not going to restore your land. And He makes it very plain that when a nation like Iraq is attacked and overcome by the coalition forces, it wasn't the power of the United States and England that took over that nation. It was the will of the Father that decided that Iraq was going to lose its independence. Now, why would the Father decide that Iraq is going to lose its independence?
It has to be according to what His Word says.
There you go. I could think of two things. First of all, the regime was not in any way, shape, and form honorable to its own people or its neighbors, number one. Number two, the plan is that in the end times, Babylon is going to reemerge. And if Babylon's going to reemerge, then the IMF and the World Bank are going to have the wherewithal to do it. And you weren't going to trust the wealth of Babylon to Saddam Hussein. Because what is Saddam Hussein going to do with all that wealth to reemerge Babylon? Nothing. He's just going to build himself 10 more palaces, that's all. He's an egotist. So what you see happening is the plan of God. And it's all meant for good. But it also fulfills all of His prophecies. On the mic. You have a comment?
The part of the Scripture where it says cannot buy or sell, that's in the commercial aspect, isn't it? It's not on the private side.
Mm-hmm.
So if you're on the private side, or you established your private accounts, you're exempt from that. Is that correct?
Right.
Because I was thinking, how can you buy and sell if you don't even need the commercial? I mean, the commercial corporation, as they say. You can grow without commercial, garden or farm.
Well, the
or anything.
merchants require commerce to wax rich. But we get our blessings from the Father, independent of commerce.
But it seems that commerce has overtaken all the natural elements in charging us for it.
Oh, yeah? They try to charge you and put you under the heading of sin again. That's what they're doing. They're trying to kill you, which is what a charge is.
Okay, rephrasing the question, we know that Babylon in the old is going to be revived according to your bands of steel around the stump and the Revelation. But America's as much of Babylon as anywhere. Biggest lie and deceit. That's why we're all here. It doesn't necessarily have to be the same old Babylon city. It would be a great deception if America starts rebuilding Babylon, the gate of Ishtar, and the Pope moves there, and every other foul thing goes on, but it doesn't detract from it's right here in the U.S. right now.
Yeah, I understand, but what you're talking about is you're talking about a territorial state, one that's not necessarily linked to the physical land masses. For instance, the United States as a territorial state overruns the world to wherever the District of Columbia and its private money system as creditors go. And that's why most of the people operating through their straw men are basically in the state of the District of Columbia, even when they're in a foreign nation or in any of the 50 collective states. And the tax codes basically say that no matter where you go as a citizen of the District of Columbia, i.e. a U.S. citizen, you're going to be a taxpayer on your income no matter where you are, Mexico, South America, or anywhere else. It's a territorial state. It's like Sears Roebuck. Sears Roebuck has no capital. It has no land mass with a metes and bounds description. But it's a territorial corporation and enterprise. Now, what we all know, literally, that the land mass that Iraq is today in its nationhood overlies the physical territory of ancient Babylon. Therefore, since there was a metes and bounds description of that state as a nation that existed, anybody that occupies that land and rules in that land has become the successor of that nation state. So there was not a promise that Babylon would be with us always. There was a promise that it would reemerge into a state or something of great power. Now, in spite of everything that the current Iraqi nation did to create lavish palaces and everything else, I venture to say that it's going to be nothing compared to what you're going to see the IMF do.
Okay, so we're looking at a super Babylon coming out of the old Babylon.
Oh, absolutely.
Powered by the IMF and the U.S.
There you go.
Gestapo.
There you go.
Good point.
So whoever took it over and whoever ruled it is who it is, because they're the puppet master pulling the strings. Now, Germany and Japan were taken over by the international bankers after the war, and all the funds that went out to bring those nations up to a modern capacity actually brought them up to a modern capacity that out-excelled the equipment, the factories, and the production available in the United States so that they could out-compete them. But in reality, what made those nations what they are came out of the source energy from the people of this country. And after all, we are the actual Israel anyway. And the Father said in Scripture that Israel would be made a nation that would serve others. And all the nations of the world would be blessed on account of us. That's what you see happening. But make no mistake about it, we are Babylon, and that's where it's going. And they're going to use that mighty wealth of that nation in order to go ahead and do that. And if you realize what that wealth is being built on, it's being built on death. Because if you understand where the crude oil comes from, it comes from the remains of living things. And so the whole, in the movie Dune, the monetary substance was the spice, which was used as a money even though it was a drug. Well, on planet Earth in this last century and a half, the money is black gold, and it's built on the remains of previous civilizations and death. Yeah.
Along with what you're saying, though, don't you suspect that they have pulled the rug on America? That's the reason our factories and everything are going overseas, and that for some reason the American currency is going down and the euro dollar with 15% back of gold is going up. Don't you suspect somehow the sun is setting on America?
Yeah.
i.e. thanks
Who's
to the
causing
bankers.
that to happen?
Well, I think it's God's judgment against us leaving
Absolutely.
the triune God of the Bible.
Absolutely.
But-
Leviticus 26, Deuteronomy 28.
But somehow it's got to also be convenient to the international bankers, or they certainly would not be accommodating the God of the Bible.
Well, sure they are, because
Yeah.
he makes them wealthy in this world from following their law.
How bad do you think they're going to let it go? We're going to be a
Let
third
what
world,
go?
America, we're going to be a third world country?
Oh, understand they don't want to kill the golden goose. That's another one of the reasons why they're over there, is to bring the Federal Reserve strength to the dollar back up, hopefully before it collapses. When did what become a bank? Yeah. Mm-hmm. Yeah. So everybody in the audience can hear it.
I saw on the Federal Reserve website that it's now become a bank, like your local
Mhm.
bank.
Yep.
What does that mean to what's happening?
Well, it's doing business internationally and domestically as a bank rather than just being a holding company.
To the banks themselves, the other branches of the banks.
And the world.
So I can open up my account at the Federal Reserve, right?
No, because they won't take your account. I think I read someplace where the Federal Reserve closed all their windows to the public except for one bank, which is a branch of the Atlanta Federal Reserve in a Florida city, which is open only to the public for municipal bonds. But other than that, the Federal Reserve's totally private bank. Okay, so getting back on point, I'm helping this one guy understand a little bit about what's going on in criminal procedure, and he's trying to use the commercial model, and he's been doing conditional acceptances for value. And the judge came back at a hearing in the case and said, I'm not going to accept your conditional, he didn't say conditional, I'm not going to accept your responses in this matter. So the guy came to me and said, what's wrong? And I said, what's wrong is you did a conditional acceptance for a value based on proof of claim that they bring forth appropriate charges. I said, yeah, you can stay along that line if you want to, but you've created basically an impasse because they won't bring the charges. They can't bring the charges. They're bankrupt. And therefore, it's a Mexican standoff. It's not a set-off. So the judge just says, I'm not going to take a standoff in this case, and so we're proceeding to trial. And so the guy says, what do I need to do? And I said, well, chances are when it comes to substance, you need to do a full acceptance. If it comes to procedure, then you can do a conditional acceptance. But when it comes to the charges in this case, I would assume you'd want to do a full acceptance. Now, this guy's got a friend, and this guy's friend sent him this little letter with some goodies in it from the Uniform Commercial Code. And this other guy is involved in a similar case, and he's doing quite well. He did a full acceptance, and he's doing well in that case. And he's saying to his buddy, take some of the following information that you should have and understand and apply it to what you're doing. And he writes, a negotiable instrument is governed by the UCC. You should know these things. Commercial instruments, definition. An instrument is commercial when, or is converted when a drawee to whom it is delivered for acceptance refuses to return it on demand, or any person to whom it is delivered for payment refuses on demand either to pay or to return it, or it is paid on a forged instrument. UCC section 3419, I think, subpart I. So an instrument is converted when A drawee to whom it is delivered for acceptance refuses to return it on demand. Okay, in a criminal case, whatever the charging instrument is, aren't they the drawer of that instrument? You bet. And who is the straw man? He is the debtor, yeah. He is the one basically who's being charged. He's the drawee, isn't he? Now, a commercial instrument is converted when the drawee to whom it is delivered. So, supposedly they serve the process on the agent for the straw man, right? Did he pay it or accept and return it? In the usual case of the defendant. He hasn't paid it, and he hasn't accepted and returned it. So what did he just do with the draft? He converted it. And if he converts it by conversion, isn't he liable? There you go. Aren't they telling you exactly what's happening? It's all written in the UCC code. Okay. Or it is paid on a forged endorsement. Well, now a forged endorsement. If somebody signs thereon, they could be an endorser. What you're going to see happens in criminal cases is the following. Are you the straw man? No. You're not the straw man. How do you get into the picture? You're the presumed endorser. When the drawee doesn't pay, is an endorser liable? Watch what happens to you. The endorser, or an endorser, quote, without recourse, unquote, specifically denies to assume any responsibility for payment. He assumes no contractual liability by virtue of the endorsement itself and becomes a mere assigner of the title to the paper. But such an endorsement does not indicate that the endorsee takes with notice of defects or that he does not take on credit of the other parties to the note. A drawee. This would be the defendant in a case. The drawee is the person on whom a bill or draft is drawn. A person to whom a bill of exchange or draft is directed, and who is requested to pay the amount of money therein mentioned. Isn't the defendant the one that's supposed to pay the fine, pay the court costs, pay the obligation for the conviction in terms of time served and stuff? The drawee of a check is the bank on which it is drawn. Now, is the straw man a bank? Not necessarily. Who would the bank for the straw man be? The one with the commercial energy, the living soul, backing up the straw man as the endorser. Can the straw man sign anything? No, it's fiction. Who signs for the straw man? The living soul. He's the endorser by the signature. He becomes liable. That's why you're sucked into court. You're the endorser. When the drawee accepts, he engages that he will pay the instrument according to its tenor at the time of his engagement or as completed. UCC section 3-4131, I think it is. Okay, so if you're signing as the agent or whatever for the straw man, you're really the endorser. And when the straw man, who is the debtor by definition and a deadbeat, and a corporation and a fiction and a dead person, can't pay, who do they come looking for? Whoever signed his name, the endorser. And now he's liable for the debts he endorsed. Which is why you as the agent must accept in behalf of the drawer or drawee. If you accept in return, what does that say? You're the creditor. How are you going to make the payment that as the bank / endorser / agents of the drawee, how are you going to do that? With the consideration of your exempt account, which is prepaid. You have no problem. If you go in there and start arguing in behalf of the drawee defendant, you've dishonored. They can't put a deadbeat straw man in jail or wring his little neck to get any commercial energy out of him. So who are they coming after? You, the endorser agent. And you're in dishonor, so you've made them the banker creditor, and you're now the debtor. It's all under the UCC. The person who draws something or draft, the person who, this is kind of like faked off the edge. The drawer of a check is the person who signs it. The person who creates or executes a draft, that is, issues it, and in signing the instrument gives the order to pay contained therein. That's the definition of a drawer. The person who draws something or the draft. The drawer engages that upon dishonor of the draft and any necessary notice of dishonor or protest, he will pay the amount of the draft to the holder or to any endorser who takes it up. The drawer may disclaim this liability by drawing without recourse. UCC section 3-413 subprint 2. Okay, the drawer is the person who draws up a check and the one who signs it. Now, in the case of a criminal case, who is the drawer? The state, or the county, or the municipality. They're the drawer. Now, doesn't it say here, upon dishonor of the draft? That's when the defendant doesn't accept it and return it. Isn't that a dishonor? So the state, the county, or the municipality draws up the charging instrument, tenders it to the defendant, who is the drawee. And if neither the defendant nor his agent accept it and return it, it's a dishonor. Who's going to pay it then? The drawer, which is the state, the county, or the municipality. How are they going to pay it? They're going to incarcerate you under the common law, sell a bond on you to somebody else to get the money to pay it. You're going to be incarcerated or work it off until you pay the bondholder back with interest. Okay? You understand? This whole process is under the UCC? They're telling you flat out. Now, they'll tell you, no, this isn't civil, i.e. commerce. This is criminal. Oh, really? Then what about all those crimes are commercial? Or all commerce is a crime? That's exactly what it is. This information is very powerful. I am surprised that you have forgotten. The signature without recourse is a very powerful defense against what these third-party interveners are trying to prove, as this shuts down anything that has to do with an instrument, at least if you signed it that way as an endorser. Most of their charges are based around the instruments. Study your code and study them well. If you have to go on the net to find the following codes: Peace and Blessings, Uniform Commercial Code, an acceptor. An acceptor is the person, the drawee, who accepts a draft and also engages to be primarily liable or responsible for its payment. One who engages that he will pay the draft according to its tenor at the time of his engagement or as completed pursuant to authority on incomplete instruments, UCC 3-413. An acceptor means a drawee who has accepted a draft. Drawee means a person ordered in a draft to make payment. Isn't that the accused in a charging instrument in the criminal? A drawer means a person who signs or is identified in a draft as a person ordering payment. Now, in all your charging instrument, who's ordering the payment? The state, the county, municipality, whatever. A special or a specimen signature, a representative part or a thing for study. Example, obligation of an endorser. Subject to subsections B, C, and D, and to section 3-419 subparen D, if an instrument is dishonored, that's what happens when the defendant doesn't accept in return, an endorser is obliged to pay the amount due on the instrument at the time it was endorsed. That's going to be the living soul with the same name as the defendant. Or two, if the endorser endorsed an incomplete instrument according to its terms when completed. To the extent, one, according to the terms of the instrument at the time it was endorsed, or two, if the endorser endorsed an incomplete instrument according to its term when completed. To the extent stated in section 3-115 and 3-407, the obligation of the endorser is owed to a person entitled to enforce the instrument or to a subsequent endorser who paid the instrument under this section. Whoa. Who is the person entitled to enforce the instrument? Number one, the drawer, so the state, the municipality, or whatever is going to enforce this charging instrument upon the living soul, isn't it? But it says that the party has the right of enforcement if one has paid the instrument. Wait a minute. If you pay the drawer, which is the state, the municipality, or the feds, as the drawer of the charging instrument, and the drawee is the fiction, the straw man, and you, the living soul, end up accepting it and paying it to the drawer, who now owns the instrument? You do, the one who paid it. Which is what you're asking them to do at the end of the case, discharge the instrument to you, the living soul. You paid it. You're now the owner of the instrument. You have title. And the drawer has no more force and authority because the order's been carried out. The public loses its power. You, as the living soul, and the endorser for the straw man end up having title. You control it. B, if an endorsement states it is made without recourse or otherwise disclaims liability of the endorser is not liable under Section A to pay the instrument. C, if notice of dishonor of an instrument is required by Section 3-503 and notice of dishonor complying with that section is not given to an endorser, that liability of the endorser under subsection A is discharged. D, if a draft is accepted by a bank after an endorsement. Now, you the living soul, you're the bank. Because the living soul contains all the commercial energy. So you've banked up all the energy. So the living people are the bank in fact. And don't you own the energy that the Father gave you? So who has the capacity to loan it? You do. The government has no capacity to compel you to loan it. So the government is not the principal, you're the principal, okay? If a draft is accepted by a bank after an endorsement is made, the liability of the endorser under subsection A is discharged. If a bank or a draft is accepted by a bank after an endorsement is made, the liability of the endorser under subsection A is discharged, and who's going to be the payer of the instrument? The bank, which is you. Use your law dictionary to research further and make your lawyer know that those instruments are governed under the UCC, and that the ORC, Ohio Revised Code, is parallel to it. But when international and state law conflict, it is the state's law which must yield peace and blessings. See what they're doing there? So what happened is this guy came in and he did a conditional acceptance for value of the charging instrument on proof that the drawer could prove a claim. Now you know and I know that the drawer is basically the debtor. It's the public government which is bankrupt and they can't make charges. Because they have no standing in law if they're bankrupt. Because they can't own anything, so they can't have title. So basically the public could never make a charge. But what is their purpose in the drawee, drafting scam? What is their goal? No, it's not to get you to argue. That's not it. Their goal is to run the commercial economy, the vessel. And they need it financed. Where do they have to go to finance it? To the bank. Who's the bank? You are. So they came to you to bank and they nicely prayed for relief for their problem. And you told them to go pound salt, I won't help you. Is that a dishonor? If your brother's in need. Now, if that's a dishonor, remember what the UCC said. If the bank won't lend you a helping hand, brother, then who's going to pay the claim? The drawer. Where does the drawer get the commercial energy to pay the claim? From the bank that dishonored them. You. But now they can come back and distrain you to pay the claim. See, the IRS comes to you and says, hey brother, pay the claim. And you go pound salt. I'm not going to loan you anything. And then they go, okay, we're putting you under notice of levy, dishonor, we'll distrain your goods and pay the claim ourselves and take it away from you because of your dishonor. Now, did that have anything to do with any domestic authority and law? No, it's the rules of nature. It's dealing with your brother. It's international commercial law. That's what they're doing under the UCC. So this guy did a conditional acceptance for value and says, well, if you can prove that I got to pay you, then I'll go ahead and do it. Otherwise, I won't. So it went before a judge, and a judge said, no, we're not going to accept your process here. We're moving forward to a trial. Why would the court move forward to a trial when this guy brought in a conditional acceptance for value? Because they have to have a procedure to get their money. What the judge said is, you're in a dishonor. You wouldn't loan us the money. You want us to go through hoops and all kinds of things, and that's impossible. We can't do that. So consequently, we're going to get it out of you, and the way we're going to get it out of you is we're going to go through the illusion of a trial, and after the end of the trial, the judge is going to tell the jury to find against you so we can get it out of you, so you'll think it's a court proceeding instead of a simple UCC exchange. We could just come in right now and seize it, but we'll go through the illusion. So I said to this guy, I said, they're absolutely right. Look, the judge told you the truth. So why don't you come back and do a full acceptance and tell them to settle and close this matter and use your exemption to do it. See, where is the court going to get the commercial energy to pay it after the defendant dishonored? Well, where will they ultimately get the commercial energy to pay the judgment out of the defendant's master's exemption? Why don't you just give it to them to begin with? It's heads you wins, tails they lose. Unless you're doing it backwards and it's heads they win, tails you lose. You see what's going on? The only energy comes from the exemption, which is the commercial energy of the bank, and you're the bank. Because the bank is the one that has the energy to provide whatever it is that commerce is looking for. The state has no commercial energy except from what they take from people. And they get the authority to take it from the bank when the bank won't act honorably and gift it to them. Does it make sense? So this guy's going to go back now and put in the full acceptance and ask for the settlement and closure. Okay? Now, in the events transpiring with Victoria Joy, she's still in jail. They got a trial now settled, or set for, I think, May 6th. It's about another 2-3 weeks, 4 weeks. Okay? Now, there's a lot of people out there that are, oh, gee, she was the master of this. Why isn't she out? What's going on? A lot of speculation. It's very easy to Monday night quarterback somebody else. Wait until you're in there and see what you do, what you know how to do, and what's going on. But I've told you, I believe in the past, that Victoria has been attempting over and over again to assume and presume that the Montana Freeman-style warrant that she tendered to Ventura County, California to pay for the alleged traffic liabilities here, she said that's a non-issue. It doesn't make any difference because they haven't ever come up with the warrants for the charges. And until they do that, I don't have to pay them anything. And we're going, well, wait a minute, Lee Bernasek has said it the best, the most elusive way I know. Their courts, tribunals, get their subject matter jurisdiction from the issues raised by the parties. And the only jurisdiction they get is by the issue raised by both parties. There's got to be an agreement. Remember, the only people in the equity court are the participants, the plaintiff, the defendant, the prosecution, the defendant, whatever it is. So both people have to raise the issue in order for there to be a joinder so the court has subject matter jurisdiction. Now, the state raised the issue of the Montana Freeman warrants when one of the three charges was some charge against the straw man Victoria for having tendered one of those Montana Freeman warrants to then